The meeting of the Public Safety Committee is now called to order. Mr. Clerk, would you please call the roll?
Alderman Boyd. Alderman Vaccaro.
Present.
Alderman Cone. Alderman Arnowitz.
Here.
Alderwoman Hubbard. Present. Alderman Kotar. Here. Alderwoman Spencer. Alderman Bahamid. Here. Alderwoman Boyd.
Here.
Chairman Kennedy.
Here.
President Reed. You have 7 present for a quorum.
Thank you. Today we continue our conversation and discussion related to Board Bill 234, which is sponsored by Alderman Bosley, related to the Circuit Attorney's Office. If you would come and just kind of recap it to us very briefly. Today we will have testimony from our Circuit Attorney and from Mr. Reddy Hudson, who's with the Urban League. We heard testimony last week, and so this week we're continuing both the testimony and dialogue on the bill. If you would just kind of frame it for us as the sponsor.
Yes, sir. Good morning. Thank you for hearing the bill. This bill is basically setting up a special investigation unit for police-involved shootings with Kim Gardner. Of course, you all know that we've had a few throughout the years, and generally there is some type of uproar when we have those. I think this gives us a little bit of transparency and gives us the opportunity collectively to create some protocol on how those shootings when those shootings happen, on how we proceed and how protocol takes place afterwards.
All right. Thank you. We'll first have up Mr. Reddy Hudson, who is with the Urban League and has sometime worked on these issues. We first would like to thank both you and our Circuit Attorney. You were here last week, and you stayed. We wanted to try to get you in last week, but we did not, so we do appreciate the fact that you came back today. Thank you.
Oh, I'm happy to be back, and good morning. How are you all doing?
Okay.
First, let me say, I was present at the last hearing, and I heard what was offered up, and I can tell you this as a former St. Louis City police officer, accountability is everything. It really is everything. You can have the best policies, the best training in the world, but accountability is everything, and those policies have to be adhered to. For instance, when you see Eric Garner murdered on a street corner in broad daylight by officers who are using a chokehold that is expressly prohibited by the department that they work for, that's a violation of policy. Accountability should attach. But of course, they looked into their own conduct, and very little accountability attached. In fact, the only person who was held accountable was a sergeant standing off to the side who did not have direct involvement in that incident. But I'm not here to discuss the legality so much. I know that the Circuit Attorney is going to speak after me. I will leave the legalities to the legal experts. But in prior testimony, you heard something about police officers' perspectives. That was given to you by the attorney for the St. Louis Police Officers Association, who I know. Mr. Milliken and myself were academy classmates, interestingly enough. And it's interesting how our paths can diverge. But I, too, have traveled the country, really traveled the country in service to the different organizations that I've worked for. 7 years at the ACLU, 5 years at the National NAACP, now landing back here at home in December at the Urban League of Metropolitan St. Louis. And I have worked with and talked to hundreds and hundreds of officers who have a very different perspective about what is required to establish accountability for police. I have also put together a small but growing coalition of mostly former but some current officers from Los Angeles to New York City. Vernon Wells in New York, Noel Leader in New York, Cheryl Dorsey in Los Angeles, Captain John Muntz in Los Angeles, Dee Trotter, Chicago, DeLacy Davis, New Jersey, people all over the country. And let me share with you what their perspective is relative to independent investigations performed outside of the police department. They are an absolute requirement. They are an absolute requirement if you want to establish meaningful accountability for officers that violate the civil rights, civil liberties, and human rights of the people that they are sworn to serve, it is an absolute necessity that you establish an independent investigative entity to do that work. Why do they feel that way? Let me just give you a brief example, maybe one or two. When I was at the National NAACP, I was frequently called out of my region. I had a 10-state region, but I was frequently called out of my region to help folks address issues that came up involving critical police incidents. One that comes to mind in particular was in Mobile, Alabama. I was summoned there by the Region 5 regional director because they had a young man who was shot to death by a police officer who was not yet on duty. He was going in to report to work and saw what he thought was a traffic violation of some sort. It raised his suspicion. They rolled a stop sign, a red light, something. It raised his suspicion. He pulls this car over, stops him, and it was a car with about 4 or 5 young African-American men in it. Ultimately, he shoots the driver to death. He dies. He says that the driver pulled a weapon on him, and that's why he had to shoot him. Naturally, in cases like that, for any law enforcement people who are in the room, you know when you have a critical incident involving a shooting and officers respond to the scene, one of the very first orders of business necessarily is to secure the weapon. If that subject pulled a gun on you, we're assuming that it was loaded, and he's laying there, that gun is somewhere, and it needs to be secured because there's a crowd gathering, there's people milling around, moving in and out. Get the gun. So you had several highly trained professional officers respond to that scene. No gun was located at the scene, physically. The subject was then transported. He was probably dead already, but they took him to the hospital anyway, which means that they were required to physically remove him from the street where he lay, take him to transport, the ambulance, and get him to the hospital. An investigation was done in the aftermath of that because at some point a gun was produced, and where the police indicated the gun was ultimately found was under the victim on the gurney that he had been transported to the hospital on. I went down to Mobile and met with the chief, several of his ranking officers, and they assured me that an internal investigation had been done. And in fact, they found no cause for alarm or suspicion, and everything was fine. Philando Castile, one more, was in my region. He literally is in my region. I met with his family in the aftermath of his shooting. He was a law-abiding, legally carrying citizen who was stopped because on the audio tape of the officer that stopped him and ultimately shot him, his wide nose made him fit the description of a suspect in a robbery. You saw what happened next. On the videotape, you can see clearly that the officer on his side of the vehicle at some point opens fire on him. There's another officer present on the passenger side of the vehicle prior to the shooting being initiated. He doesn't move at all. He demonstrates no sense of danger, nothing. The only time he's startled is when his partner begins to shoot. And of course, that was investigated by that department, and they found no problems. Looking at St. Louis now, closer to home, where I believe there's a call for a federal investigation, if not one is not underway already, into the brutal assaults of an off-duty police officer during one of the protests that took place here. A man who puts his life on the line every day to serve and protect this community, brutally assaulted by his colleagues even after identifying himself. I think an Air Force veteran was assaulted during that same period, who was also, I believe, a military police officer in the Air Force, brutally assaulted, according to him, numerous others. You got an officer who was shot by fellow officers after identifying himself as an officer, 2 officers here in St. Louis. You have issues that will require investigation. sometimes serious issues. You saw what happened in the Jason Stockley case. There was much emphasis given to the fact that there's already an investigative unit in the police department. The Force Investigative Unit, I believe it's called, Force Investigation Unit. One of the members, and I'll just read briefly here, I'm only 5 more minutes and I'll be done. One of the members of that unit that is charged with the responsibility of investigating critical police incidents and reporting out objectively and transparently to the community that the department serves is a Detective Stephen Burley. He's one of a 5-person unit. I'll just read briefly from a recent article in the Post-Dispatch. Detective Burley has a history of complaints against him, including 3 lawsuits related to use of force. In the latest, filed in November 2016, he was among several officers that Scott Rourke accused of watching an officer break his nose during an interrogation without intervening. While they were questioning him, he was one of the guys who stood around while this man got his nose broke, allegedly. The suit is still pending. In 2008, relative to a 2005 incident in which Burley was part of a group that allegedly entered a home without a warrant, used a stun gun on a suspect multiple times and then punched him in the head. Those officers and Burley denied the allegations, but the case was settled out of court. And in this one, which is most interesting to me, in 2006, that same Detective Burley was among a group of officers accused of using excessive force against Patrick Lingo. They were alleged to have beaten him during an interrogation after he tried to sell T-shirts at Busch Stadium outside. I guess he didn't have a license. They took him somewhere, beat him. A federal jury decided that Lingo was right, and they awarded him $91,000 in damages in that case. What stands out about that case, that federal case in which an award was actually given behind that conduct, was the judge, who was Stephen Limbaugh. He's no liberal, no bleeding heart liberal at all. But he called the department out in words, saying something, and I'm paraphrasing here, but calling into question their ability to internally investigate themselves in cases like this. He said, not only do we award this man $91,000 for his brutal assault, but in assessing your process, we see that your department at that time had received something like 400 complaints of excessive force and sustained one of them. Judge Limbaugh pointed that out. So I caution you against putting large amounts of faith in the Force Investigation Unit. I mean, by show of hands, I would ask people in this chamber who thinks that Detective Stephen Burley is an anomaly or an outlier. Like, this is rare. No. You definitely need an independent investigative unit. And as I close, let me address something else, because I see Channel 4's microphone in front of me, and I was watching Channel 4 last week when they ran a story about a former officer who made some pretty pointed remarks, I guess what I would call attacks, against our current circuit attorney. Described her as anti-police. Let me tell you something, man. When you distill the arguments that are generally presented by some in law enforcement down to their essence, what it is this. If you propose anything at all that would result in real accountability for us, that would attach some responsibility to things that we do and put us at risk of being held accountable, in reality, we are opposed to it. If you propose anything that extends more exemptions to us, provides cover for us, loopholes for us, we are for it, and you are pro-police. Anything else is anti. In its essence, the argument is, if I can't violate your civil rights and human rights and civil liberties with impunity, I can't do my job, because you don't understand what it is that I face out there. That is a truckload of BS that you must push back on. Everyone in this room that I know, and I know many of you personally, is pro-police, including myself. Many of my friends still serve on that department. I see them all the time, work with them still all the time. We're pro-accountable policing. And if that's what you want, then you better establish an independent investigative unit to do that work. Do not entrust that process or the lives that are impacted by it to men like this. Questions?
Mr. Clerk, I forgot, would you excuse Alderman Jeffrey Boyd and Spencer? Or would you have questions from members of the committee? Alderman Vaccaro?
No questions right now.
Okay. Alderman Cone? Okay. Alderman Ornowitz?
None at this time.
Alderwoman Hubbard? Alderman Kotar?
Just briefly, Mr. Chairman, thank you for being here. So, I think I agree that there should be some sort of independent investigation unit. I guess my question to you would be, what should that look like? Do you believe what's proposed here today in Board Bill 234 is the answer, or should we be looking at what, was recommended by the Ferguson Commission, which is, handing this off to, the Attorney General's office and possibly the State Highway Patrol?
I would say that in the absence of any proposed legislation here that I'm aware of, unless you can make me aware of it, that reflects the Ferguson recommendations, this is all we have. And it establishes an independent entity. So on that basis alone, I support it. You can work out the legalities among yourselves, and if someone were to propose something that was coming out of the Ferguson recommendations, which as a region, not much of that has been adopted. Not much of it has been adopted. This is an opportunity to be a lead city. A lead city. The trend is going this way, trust me. Even in the law enforcement circles that I move in, this is an opportunity for us to take a lead. So to your question, I don't know that there's any Ferguson-like recommendation alternative that is available to you. I don't know.
Does that complete your question?
Yeah, that's it for now.
Okay. Alderman Muhammad?
No questions, Mr. Chairman. I think you did a fantastic job, Mr. President. Thank you. Appreciate you.
Alderwoman Boyd?
No questions.
We thank you. We appreciate your comments.
Sam, I appreciate you.
Next, we'll have up the Circuit Attorney. And if you have others that you wish to testify during your portion,
Yes, can I
Feel
bring
free.
Ms. Rachel Smith up also?
yes. Okay.
Thank you. First of all, good morning, and I would like to thank Chairman Kennedy and the committee members for allowing me to come before this board to discuss the issues related to investigating officer-involved shootings and supporting Board Bill 234. The people of the city of St. Louis deserve a fair and impartial approach to investigating the police-involved shootings. There are two basic tenets that are encompassed in this bill. First, the investigation of the officer-involved shooting should be conducted by an agency that is separate from the agency involved in the shooting. In other words, the St. Louis Police Department should not be investigating themselves. Second, the Circuit Attorney's Office is accountable to render a decision regarding whether a shooting was justified and if there are criminal charges that should be filed. These two questions must be answered by the prosecutor of the city of St. Louis. Consequently, an independent investigative bureau, which this board bill supports, should be established that reports to and is directed by the Circuit Attorney's Office to answer these most critical questions. And that's what this Board Bill 234 does. This approach is considered best practices around the country in many jurisdictions across the nation. And I am not aware of any organizations that have held out that investigations led by the involved police department are considered to be an example of best practices involved in these incidents. When we look at the statements previously that were basically spoken by the police representative union member, Mr. Brian Milliken, you know, we have to look at the tenets of police officers are not above the law. Police officers need to be accountable. Police should be held to a higher standard. Such statements have been mischaracterized to somehow say that I am biased against the dedicated men and women on the St. Louis City Police Department that serve our fine city, and that's simply not true. These personal accusations that my decisions are guided by political calculations rather than considerations of public safety and the law are plainly untrue and unfounded. These accusations that the Circuit Attorney's Office, being the lead investigation, would result in less cooperation is illogical. This is what we do day in and day out. It's our job as prosecutors, the circuit attorney, assistant circuit attorneys, as well as law enforcement. Technically, whoever is performing the investigation is looking for the same evidence, to have the same vigor to seek the truth. It begs the question, why is there such discomfort with the Circuit Attorney's Office leading these investigations? As an office, we are strengthening our capacity and capability to further investigate crime to strengthen the office's cases. This week, we hired Mr. Anthony Box, a former FBI agent with over 20 years of criminal investigative experience. He is charged with improving the quality of our training and develop efforts in recruitment of investigators. And I believe that I, as the Circuit Attorney of the City of St. Louis, need to be accountable for the residents, to the City of St. Louis. And this Independent Investigative Bureau will work with the St. Louis Police Department and other law enforcement agencies to do that. And that's what Board Bill 234 is about. I believe we're at a crossroad in our city, our nation's histories. Prosecutors, mayors, police chiefs, and community leaders like you across this nation are trying to determine how to best navigate this most sensitive issue that is fair and impartial and promotes confidence in the criminal justice system when so many people feel the system is rigged against them. Public trust is vital for our criminal justice system to work effectively. The trust determines if community will report crime, assist in holding wrongdoers accountable, and have confidence in our court's outcomes. Assuring a fair and impartial process of officer-involved shootings is central to establishing this trust. Officer-involved shootings are difficult to prove with the best evidence, but we have an obligation to our community to hold police to a higher standard. And when an officer shoots someone, whether legal or otherwise, the public deserves to know about it. Both the community and police deserve an objective, fair, and transparent investigation. It is no longer acceptable for the police to be essentially investigating themselves. I'm asking for your support to help secure this Independent Investigative Bureau, because this is needed to swiftly and fairly investigate these cases. And that's what Board Bill 234 does. Thank you.
Go right ahead.
Good morning, Mr. Chairman. The Circuit Attorney asked me to come speak about a couple of issues.
You can step right over there.
Absolutely. The Circuit Attorney asked me to come speak on a couple of different issues. The question of who should look at officer-involved shootings and officer-involved conduct actually in the city of St. Louis actually predates anything to do with Ferguson. Chief Dan Isom, approached Jennifer Joyce, as did the captain of the homicide unit, Mike Sack, approached Ed Pistacco 2 years before Michael Brown was killed. He had had a study done from the University of Missouri on the officer-involved shootings. He began researching on what is a best practice on not only having accountability, which is absolutely crucial, but also investing his department with credibility. Because over time, that study showed him and led him to conclude that no matter how great a job the officers do, no matter how poor a job they do, the public they serve was not giving the credibility for their work. And that a best practice out of that is to have an independent assessment done by somebody who knows that jurisdiction, who knows the policies and practices of that department, who understands the needs of the community they serve, because the needs of the community in the city of St. Louis is very different than Cole County, is very different than Jackson County, very different than Kirksville. And so he sat down with then Circuit Attorney Jennifer Joyce, Ed Pistacco, and they began a conversation. And that conversation included the union and the city councilors over about a 24-month period. Out of that led to the special order that CM Dodson put into effect in 2014. That system began to be implemented, and both sides, the circuit attorney and the police department, recognized that the special order on the books was attempting to achieve accountability, but it was actually undermining credibility. The officers in that unit, and we can discuss whether we think they're doing a good job or a bad job, they were not being given the credibility for the work they were doing. The system that was in place was setting them up for failure no matter the quality of their work. On that, the circuit attorney, at the request of many community advocates, including the NAACP, including then seating aldermen, began to take the work they were already doing and make it parallel with the police department, in line with nation best practices. There was research done with meetings with multiple district attorneys across the country. At the time, the circuit attorney did not approach this board for extensive resources. She did ask for some. Some were given, some were not. The lack of resources impacted the ability of the circuit attorney to actually do what is best practices. The American Association of Prosecuting Attorneys, the APA, Prosecutors Against Gun Violence, commissioned studies on prosecutors' actions across the country, spearheaded by Missouri's own Jean Peters Baker. In that, they found the best practice is for the local prosecutor who is accountable to the public, who understands the needs of the community they serve, and understands the policies and practices, formal or informal, of the police department to head an independent investigation. And so when this board bill looks to accomplish that, I recognize the Ferguson Commission wanted to kind of take it and give it to the Attorney General's office. I was a special prosecutor for the Attorney General for 3 years. That's honorable work. They are dedicated, hard-working citizens who do a really good job, but they're always behind the 8 ball. You go into the jurisdiction you're asked to serve. Sometimes you have to figure out where the bathroom is. And so to punt this question to a statewide team, which right now has no legal authority to act, there's nothing in the legislature give them the power, the resources, or any of the tools, would be a mistake and would be a disservice to our public. The history of this issue in the city shows that taking steps on this board bill is in the best interest of the people we all serve.
Thank you. Did you have any other comments?
Yes, and just want to close with, Board Bill 234 puts into place now, because we're at this critical time, puts into place the parallel investigation and the infrastructure needed to do the things that historically have been tried. So when I hear people say, well, have you sat down? We have a history of sitting down and talking, trying to come to some kind of procedure and policy. But now we're at the point we have to implement that policy and procedure. And this bill does that. This bill talks about how we're going to sit down and work out how we coordinate. The police are still going to be involved, but they're not going to direct and control the scene. There's still going to be points in the process, we have to coordinate with collection of evidence, securing the scene, safety. But there's procedures that we have to come to the table and sit down, and this Board Bill 234 does that. It makes both sides sit down, and if we cannot agree, then now is up for us to bring the best practices of our plans to the board, the mayor, and then you guys decide with our help and presentation. And I think that is showing the accountability where it's a true compromise. It's a true compromise. We have to compromise, not in accountability, not about transparency, but in terms of all the things that I heard prior that the union representative was making of statements about officers and how they fear. But, you know, we're guided by the law. The prosecutor's office is guided by the law. We can't create law. We can't make law. We're guided by the law. And what we have is what we have. And simply, we just want a fair and transparent investigation, because at the end of the day, you know, you have to wake up and you get those calls from family members calling the office asking us, when is this going to be completed? When are we going to hear what's happening in this case? And it's devastating as the elected prosecutor in the city of St. Louis when I simply cannot give an answer, give an honest answer, because there's still investigations that need to take place. There's still a lot more work to be done. And that's why we need this 4 prosecutors, 5 special investigators, and 2 administrative support staff for this independent investigative unit. It addresses a lot of the issues that Mr. Milliken was speaking of. It is separate. It is directed by the circuit attorney. In this bill, it also talks about suspending the administrative hearings of like any internal affairs investigation. This is not saying that the St. Louis Metropolitan Police Department cannot do their internal affairs investigation, but at this point, it's suspended until this is completed. So you will still have the same looks. They can even also re-examine our work. So it's not taking away anybody's authority to do their job, but it is, in this instance, this is the accountability of the public to answer those 2 most critical questions. It is a shooting justified, and are there criminal charges that should be filed in this instance?
Thank you. We can now take questions from members of the committee for the circuit attorney. If you wish for Rachel to answer any questions, you can too, but we'll direct them for you at this point. Alderman Vaccaro, any questions?
None at this time.
Okay. Alderman Cone.
Thank you for being here, both of you. It's nice to see you down here at the Board of Aldermen. You know, I firmly believe that, you know, we do need to have more transparency in this process and a little bit more of an independent nature around how these investigations are conducted. I do have, you know, questions and concerns around the bill. You know, we talk a lot about the bill creating an independent investigative, authority through your office. You know, I often say down here that we should look at issues and not people. And, you know, while I entrust you with doing the right thing in your office, you know, there's nothing that really says that you or me or, you know, anyone else that's elected to serve this wonderful city of ours will be here in another, you know, 4 years or 8 years or 12 years or 16 years. And so my concern is not necessarily with you yourself or your staff, you know, and the kind of purview of having an independent investigation, but it's more so the function of your office as the circuit attorney. You all work very closely with the police department, at least that's my understanding, on day-to-day, you know, cases, correct?
Yes, that's correct.
So in theory or in practice, your attorneys and your investigators, you know, would work generally, you know, with the police and police officers of the SLMPD on a fairly regular basis, correct?
Well, just to clarify, and I'm glad you spoke to that, just to, not to cut you off.
Oh.
With this independent investigative unit, that addresses those concerns that you have, because this unit is separate from the day-to-day investigators and the day-to-day attorneys that are in the office, because we, as caseloads and other issues that we do have to work closely with police. But in this independent investigative unit, there are separate individuals that will have no other caseload but these cases. So they will not be a part of the day-to-day activities of the office in terms of how they deal with cases. Their caseload will only be these officer-involved shooting cases. So they're separate.
Can you provide some clarity for me on that matter then? I mean, you're requesting a relatively, compared to, the city's budget and your own office's budget, a larger sum of money, to fund this office. How many police-involved shootings are there that you anticipate investigating on an annual basis?
Well, right now, just to give you an example, it's 28 open.
So, and I guess, for, my perspective and the, audience that might be watching this, how long on average does a case like that, I know every case varies,
Yes.
but, just a ballpark in terms of what's the amount of time that usually takes to, work through something like
Well,
that?
I'm going to turn it over to Ms. Rachel Smith, who's actually done these investigations, but of course they vary, so it's no
Right.
standard 6 months, year.
I can appreciate that. I just, from my own perspective would like, a ballpark, if you will.
There was I can give an example and a range, because we can't give you one year.
Yeah, absolutely.
The former point person on this was Cynthia Copeland. She reported to me and the Force Investigation Unit. On a shooting at the Church's Chicken down off of Grand, which was on video, multiple witnesses, multiple people corroborating what happened, and clearing the officer. To pull that all together, to pull the reports, to review the videos, to interview, it took us about 3.5, 4 months. And that's probably as simple as they get. And that time, her position at the time was actually funded fully by this board to do that work only. So unfortunately, over the last several years, with the easy access of weapons on our streets, as our gun laws get looser, our officer-involved shooting numbers go up. Sadly, I don't see our legislature fixing that. So if you have multiple police-involved shootings, you can anticipate they will take between 3 months and a year if we have dedicated resources. Unfortunately, the Board of Aldermen gave us the spot with Cynthia Copeland. They took it away somewhere else, so it wasn't a net gain to the budget. So this sort of system actually would hopefully begin to address some of that length of time and investigation, because it actually lets people be truly independent with resources available to do not just one more thing on a caseload.
So, and I guess this wouldn't just be a policy. This would, obviously, it's being enacted by an ordinance, so it's actually law versus policy. So I guess if there is a situation where, Kim Gardner isn't CAO or Shane Cohn isn't, city alderman, and we get into a situation where there's a budget, consideration, and all of a sudden the budget goes away, or is this ordinance basically mandating, although we have other ordinances that mandate funding for other issues that, basically the budget ordinance supersedes all too regularly. So I'm just kind of curious how we plan on addressing this from a continuity perspective.
Well, I think, in the bill specifically, it talks about it's 1% of the annual budget of the City of St. Louis Police Department. So I think that it's limited to that, and I think that, of course, the board has consideration to always look at funding sources if they've done before every year. But I think that when you have it 1% of the annual budget of the City of St. Louis Police Division of Police, that addresses it in terms of that's the amount. And so we're looking at, I know in the bill, I heard from testimony last week that it's of the total budget of, I guess, the retirement and the total annual budget, so it's about 1.6, but we can look to change that if the Board of Aldermen wants to change that, because we were asking for at least 1.3.
Okay. And I apologize, Mr. Chair, I don't actually have a copy of the bill in front of me to review specific particulars of it at the moment. I have read it in the past, obviously, but, to reference specific portions of it, I'm not able to do at the moment. But thank you, Mr. Clerk. So the
I'm sorry,
other.
just let me clarify
Oh,
that.
absolutely.
And so just to look at the bill, sorry for cutting you off. And it also says at the end of the fiscal year, any unused portion of the annual allocation to the fund shall not be carried over to the next fiscal year. So we don't use, it goes back. So
Right,
I think
there's
that
no
also is a
rollover.
fail-safe for if there's any unused money.
So I guess the question, and I can't remember who asked it of the last speaker, was relative to the Ferguson Commission. I believe their recommendation was that these investigations are handed over to the State Highway Patrol. And if there was either a companion bill that was introduced where St. Louis police officers secure the scene and await for the Highway Patrol, which are now very much more present in our city than they ever have been, frankly. So, I know that there was a concern around response times from the Highway Patrol at one point, but now, because they were headquartered out in St. Charles and, didn't actually patrol the highways in the city, but that's since changed. Now the Highway Patrol is very much active on our state highways and interstates. So I think the response time would probably be much quicker than it would have been previously. And then the State Highway Patrol then gathers the evidence and then hands that over to your office. I mean, to me, that seems to make a little bit more sense, but you all are obviously, in the weeds, maybe a little bit more familiar with that. What are your thoughts on that kind of structure?
Well, I'm going to have Ms. Rachel Smith answer some parts of that, but in terms of the structure you're talking about, I think it is addressed in this bill because, as we talked about, we have our independent investigative unit, and we also have members of the St. Louis Police Department who basically are exchanging, information. It's this parallel kind of unit that addresses the response time, addresses the procedures of the local jurisdiction, addresses the issues in terms of processing evidence. And I think that, when you get to, I guess you're talking about the Highway Patrol, that can also increase, response time, because a lot of times, even with the Highway Patrol, they will also use the local jurisdiction in terms of processing evidence. So I think in terms of working with the St. Louis Police Department, in terms of the independent investigative unit controlling the scene and working with them parallel, I think that addresses all those things. And I think that flows better than we going to, for example, the Highway Patrol that may have some limitations in what they do and how they process things, because sometimes they process things differently. But I'm gonna let Ms. Rachel Smith kind of give you the intricate details because she's done that.
Okay.
The Highway Patrol have excellent and amazing people working for them. Their DDCC, Division of Drug and Crime Control, is the one that does primarily their investigative work. But the patrol is set up as a traffic enforcement agency. Primarily, their job is the highways of the city. They are not structured, candidly, like many law enforcement, don't have the resources they need to provide this sort of specialized focus in a jurisdiction that they're not from. So that would be one of my personal concerns. But on another more fundamental issue, the idea that we want people who know that community, who are responsible to that community, and who can work with citizens from those neighborhoods, with the local branches of the NAACP, protest community, that's not something we can put on the Highway Patrol. Furthermore, we can't guarantee that they won't be shifted within the next 6 months. We can't guarantee continuity because this board will have no control over the manning or the staffing done by the Highway Patrol. And so the idea and a best practice is to allow the people who know that community, who can get to witnesses, who have credibility with both the law enforcement and the citizens, And that's a huge lift for the Highway Patrol, given that they're based out of Jeff City or out of Troop C over
In St.
Logan
Charles,
Springs.
right?
Yeah. So it's really kind of undermines the idea that it's about local accountability, and it's about local credibility. Because if an officer-involved shooting should clear that officer, the public needs to believe that. If that involved shooting means the officer should be charged, the police need to be comfortable with that. And having a team that knows the practices of that jurisdiction, who knows the players in the community, and who knows the policies and practices of that department are really what's in the best interest of the citizen.
Okay. Thank you. You have some pretty compelling answers there. I really appreciate it. And I don't have any further questions at this point.
Okay.
Thank you.
Alderman Ornowitz?
Good morning, thank you for coming over. So, I'm listening to everything about independent investigations and everything else, so I guess Rachel probably could answer this one. So, didn't we have independent investigators in the circuit attorney's office when the last circuit attorney was here? Or did we not?
For what issue?
For shootings, police-involved shootings, weren't they notified?
They were notified, but they didn't have primary jurisdiction, they didn't have the authority to seize, and by agreement, they were the second seat to the FIU, Force Investigation Unit with the police department. One of the challenges with multi-agency investigations and opportunities, one of the challenges, you don't want to step on each other. And so you have to have a method and an investigative plan, an agreement on who goes first. And so the agreement at the time, and candidly, that's the current agreement, was that the police department FIU goes first. Because you can't compromise your witness, you can't compromise evidence integrity, scene integrity. So no, in that sense, no. Now, were they independent in that they answered only to Jennifer Joyce? Yes, but they were not primary. And that is the key to rapid, quick, credible results.
So, if we establish this independent investigative unit, so will they be the first on the scene to
Yes.
secure it?
Yes, we will be the first on the scene in conjunction with, if there is still a force investigation unit, but it's truly this parallel process that the previous circuit attorney saw that was best practices around the country, that we need to implement this parallel, a true parallel investigation. So that's what this does. So we will be the first on the scene. At the same time, the police department decides that it's going to be a force investigation unit or whatever unit they decide to handle these scenes, we will be there together, but we would control the scene, we would direct the scene with the force investigation unit or whatever entity they decide. And so that's what we're trying to do here with this bill.
So has there been a problem with the, I guess, who was the gentleman, Roger Engelhardt, with property and evidence going back and forth with the office?
Well, you know, we had a conversation and there were some issues, but I'm going to speak to what happened since I've been in office. Basically, this bill addresses those concerns of property. This bill does this because we are at the scene at the same time. We are controlling the scene, so we're able to direct the collection, direct the taking up of the evidence, the transferring the evidence to that entity, and the processing that evidence. So we have control, so it's no longer this process how we have right now, where basically if the police decides to turn something over, and whenever they decide, that's when we get it. So at the same, it's real time that we're able to exchange this evidence and information that is needed to, one, make quick decisions, be thorough, and at the same time, exchange ideas and exchange the techniques that are needed, the best practices that to address these officer-involved shootings. So that's what this bill does, and addresses those issues that, yes, you did hear with Lieutenant Roger Engelhardt in terms of some of the evidence that we've never received, basically from cases in 2015, and still do not have today. But we're not here to indict Lieutenant Englehart. We're not here to indict the police department. We're here to put the solution in place, because I think that as time has gone on, the pressure of these cases, because as Ms. Smith said, when I took office, we had one officer-involved shooting every 2.5 weeks since I took office, because of the proliferation of guns. And so that need to address these cases in a more efficient and effective manner is critical. So that's what we're trying to do. We're trying to start anew and not blame anybody, but say, look, we have to put these policies in place, and that's what this Board Bill 234 does.
And I'm not trying to blame anyone, but it just seems like it's what it sounds like on all ends. But I would just say this, and then I'll be quiet. Former Judge Jimmy Edwards, who is now the Director of Public Safety, for years has been a judge and probably been one of the most fairest judges I've ever seen, especially when trying to, tutor the young kids through and give them chances to straighten their life out. I mean, I have to, take his testimony in consideration to how he feels. And I think he's credible also, so I hope somehow we can just all get this worked out and quit, and put it behind us and make this city all work together. So I wish we could figure out how we can get witnesses to come to courts, because it seems like things are happening and, we're back out on the streets again. So, but I appreciate your efforts. I really do. You got a challenge.
And I thank
know
you,
that.
Alderman.
I wouldn't want to be the circuit attorney.
You know what, Alderman, I thank you for that, and this bill does that. This bill is not, where the circuit attorney is just sitting here making these policies and procedures. This actually is bringing us to the table to discuss these things that you're saying, to have his input, and to make these policies that are so important to address the issues that you're talking about. You're talking about trust in the criminal justice system.
Yes.
And when you have people who feel that they can't trust the system or the process in certain types of cases, then how can you expect a witness to come forward when they are afraid to even, if we have law enforcement afraid to be a part of a process, how can we ask the community that we have real concerns about retaliation and things that we deal with day in and day out? There's real concerns. There's real issues. And so when we have, this is the start. This is not a Kim Gardner bill. This is the City of St. Louis bill. This is us addressing, since we talk about Ferguson all the time, Ferguson was the start of these conversations in this region. We were the ground zero. And now we have expanded beyond Ferguson. That's not taken away from Ferguson, but things have evolved and happened over time, because Ferguson was the first we had to look at this issue. It's grown. And in the city of St. Louis and around this country, we're top. I think we're almost close to #1 in open officer-involved shooting cases. So this is a way that we are, like you said, making us come to the table, put all this stuff behind, and let's move forward. And I think that, like you said, Public Safety Director, Police Commissioner Hayden, I feel confident that we can sit down and we can have robust discussion and move this forward.
Right. And in the same token, just a side note, unfortunately, the Jason Stockley case, maybe the judge could have handled that. Maybe there could have been some other options on charges, sentencing or convictions. But I think in the bottom end, what I read, unless I'm wrong, there actually was no new evidence. So I guess my question is, if there wasn't, why wasn't the people who testified prosecuted? And that's just a personal thing. And that's not on you, that's on the former circuit attorney. So they even testified there was no new evidence, so.
A lot of people talk about the Stockley case, and I don't really talk about it.
You were just
because
fairly new, so.
we did our job, and basically,
Right.
what the courts made a decision, regardless of the outcome. I think the case was, investigated, it was charged, and it was a fair process. Now, the outcome, some people may disagree on that outcome, but I think that those are the decisions that the circuit attorney has to make. Right. And I think that we have to look at doing a better job in terms of addressing officer-involved shootings, regardless of whether there's charges that will be issued or there is a eventual potential case. We have to deal with how we proceed in this jurisdiction on these type of cases.
I agree.
And I think the Stockley case, not to speak specifically about the outcome, I think that shows that we have to address this, and it's a critical need right now.
Yeah, and we probably should have fired that lieutenant. Thank you.
Alderwoman Hubbard, any questions? Alderman Kotar?
Thank you, Mr. Chairman. Thanks for being here today, guys. I want to talk about a couple of things. I want to start with the funding of this proposed unit, some staffing questions, and then some questions about legal authority, if we could. You've got a copy of the bill, right?
Yes.
Okay. You referenced this a little bit earlier, and I think I brought it up last week. There's just dollars and cents. What are we talking about? As this reads, it says St. Louis Division of Police. I see the fiscal note says $1.6 million a year in cost, which I guess would be the department's budget plus their pension obligations, so 1% of both of those. Is that what you're looking for, 1.6 million a year or 1.3 million a year, which would just be the department's operational budget?
I think it was 1.3.
1.3 is the number you had in mind?
I think that was a drafting error
That's
that we
fine.
can address.
Okay, so 1.3, not 1.6. Okay. And your budget, I think for fiscal year 18 was roughly $7.6 million. And that's for, walk me through just sort of general staffing at your office. How many attorneys, how many investigators?
We have about 60 attorneys and about 30 investigators.
And then support staff,
We have about
ballpark?
30.
30? Okay. So you're at about 120 employees. And so in this, I seem to remember, I don't remember the exact number, but Prop P, passed in November, provided a significant amount of money to the circuit attorney's office. What was it, about $1 million, or was it more than that?
A little bit more than that.
Okay, well, I don't remember the number. I'm sure you do. Is it $1 million what? $1.3 million?
I think it was about 1.3.
1.3, okay, conveniently the same number we're talking about here. So, in addition to the $1.3 million budget increase,
Not to interrupt, but the measure was actually 1.2 million.
1.2, thanks.
1.2 issue
Okay.
received for property.
1.2, thanks, Alderman. In addition to that 1.2 million, you are now seeking, I guess, an additional 1.3 million for this unit, right?
Yes.
Okay. And what, that additional 1.2 million from Prop P funds, what are you, have you decided on how those are going to be allocated?
Yes, that's going to be allocated to the resources currently of the Circuit Attorney's Office. So it's going to be in terms of, like we talked about, is attracting assistant circuit attorneys and retaining assistant circuit attorneys and staff.
Okay. All right. Staffing for this. I think it's referenced in the bill on page 7. So you're looking for 4 prosecutors, 5 special investigators, and 2 administrative support staff, is that right?
Yes.
And so those folks would be exclusively dedicated to this independent investigation unit?
Yes,
They wouldn't have any cases from the regular, the attorneys wouldn't have any duties with the regular trial docket?
it will not.
Okay. And so, I guess, walk me through, and I know we don't, you know, the board bill speaks to the fact that we still have to, they would have to develop the policies and procedures, which aren't in place, and I understand that. You've spoken sort of generally about what you think that should look like. So, could you walk me through, you know, if we've got an officer-involved shooting, and the IIU, as you're proposing, shows up on the staff, is one of these prosecutors in charge? Is one of the investigators in charge? Who's going to run that scene?
Well, actually, it's going to be, the investigative unit is going to respond with a assistant circuit attorney that's dedicated to this unit, as we do right now.
Yeah.
But what's going to happen is, as in terms of like the force investigation unit, they'll control the scene. So they will basically coordinate with whatever entity to respond. They would basically look for the safety issues in terms of working with law enforcement to make sure that the area is safe.
Sorry, who's doing that?
The St. Louis Police Department, we're working with the other entity to, in terms of controlling the scene, they're going to be working with current St. Louis Metropolitan Police Department Force Investigation Unit, if that's what the police department decides later on, to help control the scene in terms of safety. Because this is a parallel investigation, so we're not saying we're taking out the
Right.
police department, but we're working together. So, but we will be the first to respond. We will be the person that controls the scene. That's not saying that the police department will not be there. They still have to be directed to control, map out the area, block off the area. If there's any safety protocols, if there's someone injured, we still have to have the police department helping coordinate with our independent investigating unit to address that stuff. We have
Okay.
to secure the scene.
Right.
So we have to make sure that, like we said, crime tape, personnel, we have to have an entry and exit point. We have to work with, that's why we need
The police are doing all of that.
our independent investigating unit and the police are working together to do that.
Okay, if I could, so you keep mentioning a parallel process and a parallel investigation, but as written in section 3, page 4, under authority, I mean, this clearly states that the circuit attorney assumes primary responsibility from the police department for these investigations. And you'll have the authority, the circuit attorney will have the authority to, quote, take control of any investigation or pending investigation. That doesn't sound parallel to me. That sounds like you're taking control, commanding the investigation, directing police on how to use their resources based on how this is written.
What that language is basically when we talk about taking control, is when we are first to the scene, we basically direct our investigative unit to control the scene, make sure evidence is not moved, make sure we're able to block off the scene with the officers and then do our job. That's when we mean control the scene. Look at how we have to evaluate evidence, how we interview certain people, but the police will be there. So it's not, even though the words are control, it's control in terms of looking at the evidence, actually working with the police in terms of controlling the scene. We'll do that, but we're parallel, and that's why we are sitting down to address those issues, because there's issues like you're saying.
Right.
That I'm saying that we have to work out amongst each other, because we have a function as well as they have a function, but I think in terms of directing the scene, it is our job to direct the scene in terms of that criminal investigation, because that evidence is important to where evidence is. When people move evidence, we want to control that. We want to make sure we see evidence where it's at in real time, not after it's been collected and picked up and then they say, well, I found it over there. We want to look at measurements and different, pieces of data that we can look at trajectory of bullets and different logistics. So we have to be a part of controlling that scene, because those are important in making our determination of if the shooting was justified, as well as if there's criminal charges. So that's why we talk about controlling the scene.
Right. So I guess I'm struggling with this parallel investigation concept because,
Ms. Smith?
yeah, if I could, let me finish my question and then you guys can comment, because all of those processes you just talked about, that's not contemplated in what, in the resources you're going to have for this unit. You're not going to have, you're going to have 5 special investigators and 2 administrative support staff. You're not going to have ballistics people. I assume you're not going to have crime scene photographers as part of that. Maybe you are. But, I don't understand how this is parallel if you're still going to be relying on all of these various departments within the SLMPD to handle this investigation.
It's perimeters. So at these scenes, there are multiple perimeters. There's the interior crime scene, which is the area where the crime actually occurred, which is usually as small a space as you can get it. Then there's another perimeter, and depending on the danger to the community, I've been at scenes where there's 3 levels. That is not something that this unit is intended to do, is handle all 3 of those.
Right.
But this unit is intended to be, and I hate to quote W, but to be the decider on that interior crime scene perimeter. So some of these issues on where the dividing line is, where the police department handles the first perimeter and where they handle the safety perimeter, has to be part of the protocol and discussions done that is anticipated by this committee, and sort of where those lines are drawn. But this unit is designed to be the person who decides, when do we seize what? Who seizes what agency processes what? So when it says control, having the opportunity to make the decision, do we swab the hands or not? Do we do DNA, and what do we do DNA on?
Right.
How do we collect that? So that.
But the processing of all that would still go through the crime lab in the police
Or
department.
to the highway
Or to
patrol.
some other.
Some of it's now sent to the highway patrol.
Okay.
Some of it is sent, and this unit would be trained on So it's about who gets to be the decision maker on that primary control. This unit could not handle a secondary perimeter or a third. So that's when we're talking about parallel, there's no contemplation that we would have to handle all three perimeters and, potential violence extending into the neighborhood. Some of these scenes are very
Right, they're
volatile.
dynamic, yeah.
That would be the responsibility of the police department.
Okay, thank you for clearing that up. All right, so along these lines, talking about, I guess, authority for this, I remember back when we passed local control in 2012, there was a big question about, okay, well, is the Board of Aldermen or are all these local political entities going to start, meddling with the police department and its operations? And there was a state statute passed relating to this, 84.341, which I'm sure you've seen. If not, I've got copies here. Have you guys done an analysis? I mean, I don't understand really how what you're asking for and the authority you're looking to take from the police department, how that jives with 84.346, which prohibits, local elected officials or appointed officials from acting in any manner to impede, obstruct, hinder, or otherwise interfere with a member of the municipal police force, meaning the St. Louis Metropolitan Police Department. So how does what you're proposing, jive with this state law from 2012?
I think it depends on if you consider the adequate investigation of officer-involved shootings and an effort of their funding agency to make sure that happens in meeting. That statute is about governmental obstruction. That is about an alderman calling and saying, hey, don't look at my cousin. That is not about what resources should be dedicated to a key issue essential to public confidence in the community criminal justice system. It's about making sure that local elected officials don't interfere with the individual conduct. It is not about policies and practices of an agency.
Okay. And I recognize that this statute's fairly new, and I don't think anyone's I looked, it hasn't been cited in really anything. Okay, so moving on to, I guess if this were to pass, the sit-down that you guys, the circuit attorney and the police department would have to come up with this investigative protocol in Section 4. So assuming you guys do come to some agreement as written, then I guess that protocol gets given to the mayor and to the Board of Aldermen. Is that right?
Yes.
And as written, it says that the Board of Aldermen shall vote to adopt without amendment by ordinance. So I'm curious about that, and maybe that's a drafting error, I don't know, but I'm not aware of any incident where this board would, take its own authority away to amend or review pending legislation in front of it and tie our hands to say we have to pass something as is with no changes.
Well, I mean, I didn't draft the bill, so I think that's more of a drafting question, but I think that, you guys can change that if that's what the board and
So right after the initial response happened to where they're supposed to come to some type of agreement, we necessarily don't have to adopt that. If we don't adopt that, then within 10 days, the City of St. Louis Division of Police and the Circuit Attorney let's go to section page 6, line 9. If the Circuit Attorney and the Commissioner of the St. Louis Division of Police, after meeting in good faith, are not able to come to an agreement on investigative protocol within 30 days following their initial meeting, the Circuit Attorney and the Commissioner of St. Louis Division of Police shall within 10 days thereafter
Right.
submit a written proposal containing the recommendations of investigative protocol to the Public Safety Committee of
Thank
the
you,
Board of Aldermen.
Alderman, but that's not what my question was.
Right.
My question was about if they do come to an agreement, if the Circuit Attorney and the police do come to an agreement, as you have this drafted, it says we shall vote to adopt it without amendment. You're talking about a situation where the police department and the Circuit Attorney's office don't come to an agreement.
Right.
That's what line 9 is. Then it comes to this Public Safety Committee, and we'd make that decision. But as written, if they come to an agreement, we have to just adopt that as is without amendment.
Well, I think that gets into the policy and procedures that we basically come together about. So I'm just saying, if that's something that the board may want to change, I think that you will have authority to change that. But if it's an agreement, what would the need to change that agreement between the two entities that are basically,
Well, if it's an agreement that you guys agree to, I mean, why would we need to pass it then?
no, I'm saying, well, we don't have an agreement, but I'm just posing the same question to you. If there is agreement, I'm just saying, if you guys have authority to look into our agreement, if you see that something is against any kind of ordinances or whatever, but I think that you have that authority regardless of this language. I think it's speaking to if we agree to a protocol and procedure that both sides agree to,
Yeah.
I don't think it's taking away your authority if you disagree with something to come back and look at it.
No, but as written, this board bill does, it would say we can't amend it. But, that's a in the weeds drafting issue, I think. But I mean, I would take umbrage with, any, whether it's the circuit attorney's office or any department of the executive branch of city government telling the legislative body of the government that you have to do this without amendment, because I think we get into all sorts of issues regarding separation of powers there.
Well, I think that, first of all, it's not our intention or the intention of the bill, so maybe that's a drafting issue that, of course, we can look at. But I don't think that was the intention of the bill as proposed. I think it was really about the agreement of the two entities, and we present that to you, to the board, and to the mayor, and I think that was the intent of it, but I cannot speak to the drafters of it.
Okay. And I guess my last question is not necessarily related to the bill, but more a question in response to the conversation and the presentation by Mr. Milliken from the POA last week. He talked a little bit about this issue that's going on that I've read about in the papers and heard about at the courthouse involving, officer-involved shootings where we've got, a person shot by the police who's then criminally charged, and an officer who's sort of in limbo, under investigation, and has been cleared, being compelled to take the stand. Didn't get into this issue of whether you're having preliminary hearings versus grand jury proceedings for these officer-involved shooting cases where the suspect lives and is later charged. Could you, respond to some of the stuff Mr. Milliken talked about last week? Why is your office now taking what are called victimed crimes, where the state's not the only victim? You've got either a citizen that's a victim or someone else. Why are these now being sent to preliminary hearings, specifically the cases involving police officers? Why are those going to preliminary hearing instead of the grand jury process?
Well, I have to be cautious because, I am being in litigation about an issue. So just to give you an overview, in these officer-involved shooting cases, we have instances where we have a situation where officer may say X, Y, Z person shot at them and they discharge their firearm. Now,
The officer discharged their firearm?
The officer
Okay.
discharged their firearm. So in that instance, under the special order of the police department, there is automatically an officer-involved shooting case open.
Right.
As well as the officer will come to our office and present a case that says this XYZ person shot at the officer and it was assault of a law enforcement officer. So that at that time, the police officer is a victim. So it is our job in that case to also evaluate the criminal aspect of the incident against the police. That police officer is at that time a victim. So you have two different cases. You have an officer-involved shooting case with that same incident, as well as the victim case that the officer is a victim and the witness to say XYZ did this to me.
Right. And
So just to answer your question, so I have to separate those out because that's important. Well, this bill addresses the officer-involved shooting case, but what you're asking is about the everyday work that when officers come into the warrant office and present cases that there are victims on, that we review those charges for potential criminal crimes against that individual. And so in that instance, we go through the normal process. They come to the warrant office. We hear the officer say, this happened, review what we have, and we proceed charges on that individual. Now, what has been happened recently, which has not happened under the previous circuit attorney, we had these same incidents that officers were participating in both processes. So at this point, there have been numerous times where the officer has decided that they do not want to participate where they're the victim. And at that point, we are based off of the officer's statement to our office saying, this happened to me, issuing a case. So,
Right, and I guess that's where my question is, if you're finding the statement of that officer who's the victim credible enough to issue criminal charges against a suspect, and then there's still a parallel force investigation unit looking into that officer's conduct, what I guess I'm struggling with is, if you find that officer's, observations and testimony, and you believe he's the victim of a crime at the hands of the suspect that you've charged, why can you not clear that officer, or at least say, hey, you're clear in that shooting, in that particular incident, you're in the clear, please cooperate and assist the prosecution?
because those are two different investigations, and
But I guess, why does that investigation take so long if you believe the officer to the point where you've taken his observation and testimony and charged another person with a crime?
So I'm gonna pose the same question to you in terms of the officer. If they are telling the truth, right, and they said X, Y, and Z happened, why are they worried about the officer-involved shooting case?
Well, I would frankly, if there was
If, like you said, in your
potential
example,
criminal
if they're telling
charges
the
pending
truth,
against anybody,
they're telling the truth, and they're saying this happened, and like you said, we are going off of what they're saying.
Yeah.
Why are they worried about the officer-involved shooting case?
because they're still under criminal investigation, and they have the same rights against self-incrimination as any other criminal suspect. And this is where I guess if you're, the quote, if you're telling the truth, you have nothing to worry about argument, I guess that's, things can be taken out of context, words can be twisted. Why would you open yourself up to cross-examination and everything else, and if you haven't been cleared by the agency you're supposed to be working with and assisting?
One of the reasons, and this is why this unit is so important, because you raise a really important issue. Those officer-involved shooting investigations, the investigation and that split of the process starts with the police department. They're the ones who separated those two things and are having district officers bring us the assault on a law enforcement officer and asking parts of our office to review what they're saying to see if they're a victim. The length of the investigation is driven by the work of the FIU at the police department, and that's been that way since 2014. It has nothing to do with the practices or policies of this circuit attorney. The recent assertion, only within the last year, of the Fifth Amendment, what we're talking about is an officer's been a victim of a crime. The office in the warrant office, the separate part of the office that reviews those things, has decided to prosecute somebody who has tried to shoot, kill, or harm an officer. Some officers have decided, once we've charged somebody, locked them up, and held them in jail, to assert their Fifth Amendment privilege. And in doing so, they take our witness. It becomes like any other case. We don't have an available victim or witness.
Right.
And so it forces the circuit attorney in the position of dropping a case against somebody who tried to hurt a police officer, in the opinion of one, while we still don't even have conclusions out of FIU from the police department. You have pointed out one of the most essential needs for why this bill is necessary. We have to find a way to speed up that process, to consolidate some of the decision-making, to allow there to be a better exchange of information. That's a fundamental part of officer-involved safety. The decision of some officers, not all, to assert their fifth when they've been a victim of a crime is what has driven some of that issue. That did not happen prior to 2017 at all. The same issues have existed for the last 4 years. They only started asserting the fifth in 2017. And what that means, if we don't have that witness or victim, we all know we have to drop the
Case
case.
gets dropped, yeah. Okay, well, Chairman, I think that's enough for me for now. Thank you, Madam Circuit Attorney, and thank you, Ms. Smith.
Thank you.
Alderman Muhammad,
I have no questions, Mr. Chair.
Alderwoman Boyd.
I do. Thank you for coming, Circuit Attorney and Attorney Smith. And I want to applaud you for standing by what you campaigned on. You were fighting for the residents to make sure the truth would always come out. And then Attorney Smith, thank you for bringing up about the previous Chief Dan Isom, because I remember when they did that study, And people keep focusing on Ferguson, and I think he was ahead of the game, and nobody used that information to help us be better at what we were doing. So, I mean, it's real clear, everybody is Ferguson. But that was one time that the city of St. Louis got ahead of it, and nobody took that information to utilize it to make it better for the system. I don't think people are against the police. I just think people want justice, and that's all they're looking for. And I think as the circuit attorney and Alderman Bosley that created this bill, they just want justice for the people and to make sure everything is fair. It's real clear, you know, the Alderman Calder kept saying about working with the police. We have to work together. It's real clear, you have to work together. But everybody has to be able to put everything to the side and listen. And I think that's what hasn't been happening. Everybody put their guards up and say, oh, you attacking us, and I don't think that's the case. I just think everybody wants what's right and what's just for the community and the police as a whole. So me being from a police family, I respect the police, but it's real clear everybody has to be held accountable. So that's what I wanted to say. Thank you very much.
Thank you, and I think that's a good point, because this bill is not against the police.
Right.
This is supporting police officers that do a hard job day in and day out. The circuit attorney's office, you know, I was asked to speak on some of the attacks of the representative from the union saying that police officers somehow feel different about me as the circuit attorney in terms of these cases. But, you know, I have asked that same individual, I said, so you're telling me that police are above the law? And I was told yes. I was told that police should be held to a different standard, because like I made the example, if I'm charged with a crime, I have to go through the same process, just like every one of you guys have to go to the same process if you're arrested or charged with a crime. So why is the police somehow representatives saying that they should be above a process that all of us have to go through? And I think that we are held to a higher standard when you have that position, and I believe this bill supports police. It also puts protections, because this is not a one-sided bill. This is not Kim Gardner, this is what she wants. This is bringing us to the table to address the issues you talked about, because we do need to sit down, because what is at stake is the whole criminal justice system. Because when you cannot sit down and work amongst each other, then guess what? The bad guys are winning. People out here are preying on our communities are winning. Violence is winning, because when you think about victims and witnesses who we ask every day to come forward to be a part of this cruel process, the criminal justice system as a witness and victim is cruel, and we ask them to be a part of this. So if a police officer who has certain training and skills that we have over many years knowing the good work that they do, if they're scared of this same process that we ask other people to come and participate in other incidents, why is it different? So I think it's the time that we have to sit down and address these issues and come to the table, and that's what this bill does. This bill is not just for Kim Gardner. This is for everyone sitting here that is accountable to what happens to law enforcement as well as the public, and I am the only elected official accountable for public safety in the city of St. Louis, and that's why this bill is so important. So I thank you today for speaking to me and allow Ms. Rachel Smith, that has put in over 20 years of work in this office. I mean, she's been a prosecutor for many years, and she knows the evolution of this problem and how complex. One case is like 15 cases. So some of you guys may think on the board, oh, it's only 28 cases. You have to multiply that by so many different factors, because this one case is so complex. So it's time for us to address this issue, and I look forward to sitting down and working with each and every one of you, as well as the police department, the public safety director, to address this most critical issue. Thank you.
We thank you. Your information was most helpful. Thank you. I just want to address something to Alderman Coulter. There's been a state statute limiting local officials interfering with the function of the St. Louis Police Department for decades. It was revised in 2000, I think, what's 14? 12. It was revised at that point. But we struggled with that as it related to the Civilian Oversight Board, because that was on the books at the time. So it wasn't new in 2012. Okay. It was just revised. Okay, thank you. Thank you very much. Does the sponsor have any other statements right now?
Yes, I really appreciate you all hearing the bill. Thank you, Circuit Attorney. I just wanted to add to, and I do appreciate Alderman Kotar's responses there. We do need to never take ourselves out of a position to where we are not in a position of power when it comes down to having control over some of the departments and things that go on in the city. So at some point in time, we do want to make an amendment to page 6, line 6, where it says we shall vote to adopt without amendment, because that is something we don't want to do, is take ourselves out of a situation where we don't have control over protocol. One of the things that I think is great about this bill is it gives us a little bit control over protocol. We are always generally proposed questions in our communities about what we're going to do about the police. You know, how can we get more police involved? How can we stop this or that? And generally, you know, our answers are, you know, we'll see what we can do. We'll see if we can talk to the officers about this, or see what we can look at. I think this actually gives us a little bit of power when it does come down to talking about what protocol looks like, because everything in life is protocol. It's how you proceed, you know, with the daily motion. So when it comes down to a police-involved shootings, if we all collectively, especially our public safety board, which you know, this is empowering if we change the language to the correct way. If we all were to vote no and did not agree with the protocol set forth by the circuit attorney and the commissioner of the St. Louis City Police Division, it gives the public safety committee some control over what that protocol looks like, and then it will come to the Board of Aldermen. So I think that is an important piece that we need to change. I do think a lot of the things that are going on in our city when it comes down to building trust is based on police relations. One of the reasons the public does not trust the police is because there is no transparency. It's the way the public feels. We feel like anything can be done and there is no disciplinary actions being imposed on those who are needing it. So having an elected official, I think, who we can put in office, even if Kim Gardner is not here, where we control some type of the protocol, gives the people some type of, I think it gives them a balance where they can say, hey, what does my elected official feel? How do they feel about police engagement? How do they feel about the way things are being handled when it comes to the Metropolitan Police Department? And you will make more conscious decisions on who you elect, because your elected officials do have a little bit of control over how protocol is made. So I think that is one thing that we really need to focus on. A lot of times we focus on money. I think there is no price on people's lives. People are dying every day, all the time. And, you know, if there's plenty of people who would spend every dime they had if it would bring their loved ones back. So that's one thing we do need to focus on. Not so much on funding. Sometimes everything has to be funded, but what is the outcome? How will our city be looked at in 5 or 10 years from now? What is our actual goals? And sometimes we kind of fall behind because we aren't looking ahead. We definitely need to start looking at how our police relations will be within the community within the next 5 or 10 years, and how we can really build up what we would like to see, you know, in our communities, that trust. We shouldn't be running every time we see a police car. We should be running towards them. Our police officers should be glorified. That's the way that I feel. They put their lives on the line all the time for us, and we should be, willing to do the same thing for them when we see them out. We should show them the love and respect that they deserve, but there is no transparency and trust right now, so we need to create that in this city so we won't be looked at kind of how we're looked at right now, and change that stigma. So certainly appreciate you all taking the time to hear it.
Mm-hmm. Thank you. Thank you. That completes us on Board Bill 234 today. We do have Board Bill 222. We will take a 5-minute break to allow the president to find his way back. The Public Safety Committee meeting is now called back to order. We have before us now Board Bill 222, sponsored by President Reed. Come forward and explain the bill to us, please.
Thank you,
The meeting has started.
Thank you, Mr. Chairman and members of the committee. Board Bill 222 hopes to address some of the issues surrounding public safety that we all have been challenged with for years. As you know, oftentimes when we go through the budget and we're budgeting for whatever the priorities are in the new year, it's hard to align those budget line items directly with public safety to assure that we are budgeting in a way to directly address the issues of public safety throughout our community, our neighborhoods all across the city. Other cities across America have taken this measure so that there is a regular process for delivery, for the creation of a public safety plan, the publishing of a public safety plan, the adopting of a public safety plan, and also the funding, right? So this begins to lay out that process wherein the public safety director will create a public safety plan. We're not going to tell him or her what type of plan or what plan to create. It's up to them in their professional, understanding of what is needed to create a plan. They will deliver that plan to the Board of Aldermen and the Public Safety Committee. The Public Safety Committee of the Board of Aldermen will deliberate on it. And then past that, when we begin to take a look at our budget line items, we will have a better understanding of what is lacking in some of these neighborhoods that need to be addressed directly. Do we need more money in recreation programs and services applied to a certain neighborhood? Do we need more resources in the health department applied to certain neighborhoods? It goes beyond just putting more police officers in a particular neighborhood, right? It's an overarching plan. The other big piece of this is that it will be a data-driven plan. So at the end of each year, we will take a look at the data, take a look at what was successful, what was unsuccessful, and we will see some tweaks and changes in the plan to better target the needs throughout the communities across the city of St. Louis. We have approximately, 6 amendments? Seven amendments. So I'd like to bring up Tom Shepard to go through some of the amendments. I'd like to have Tom talk about some of the amendments that he's worked out with it.
But before we do that, let's see if we have any just base questions on the concept here. Alderman Vaccaro, do you have any questions of the president? Alderman Cone, any questions?
No questions at this time. Thank you.
Alderman Ornowitz?
No question.
Alderwoman Hubbard?
2 questions briefly. In the past, with other prior public safety directors, have we ever compiled something like this?
We've worked as you know, under the old administration, it took us 11 years to force them into putting a public safety plan together, and then they put together what was called the peer plan, and then they did nothing with it, right? Meanwhile, we are looking at 205 murders, right, that happened in the city of St. Louis just during that last year. We can no longer afford to do that, right? And what the ordinance is to set up a structure so that no matter who's in office, whether it's me, whether it's you, whether it's, who is sitting in the mayor's office, whatever, there is a structure in place that provides transparency and a consistent delivery of services and a system that will continually improve over time because it's a data-driven system. We can only benefit by it, right? So that's why the public safety director supports the current public safety director supports the effort. And it could be a great tool to help assure that he actually gets the resources he will need to address the issues, right, within various different neighborhoods across the city, beyond just sending more police officers to the area, because as all of us know, the issues of public safety go far beyond just the law enforcement piece.
I agree, and also, it looks like it'll call for very specific data from a myriad of departments and processes. So who will be responsible for compiling all the data?
The public, once we make it law, and the mayor, once we pass and the mayor signs it, all of the departments under the mayor understand that this is, they need to comply with the ordinance. We would expect the delivery of the information to us in a timely fashion in accordance to the ordinance. Once the ordinance is in place, we will have the power to compel the various different departments to assure that they comply to the ordinance. And quite frankly, if we have departments that are willfully non-compliant, that may be part of the problem. That may be part of why we continue to be one of the top, crime-ridden cities in America. So I think if we want to see a better city and we want to see safer neighborhoods, I think it's very little to ask of those departments that they actually comply with the request of the public safety director.
Thank you. No further questions.
Alderman Coulter? No questions. Alderman Muhammad?
No questions.
Alderwoman Boyd?
No questions.
All right, thank you. We can take up you have amendments, I understand, and so we can have a discussion. You can talk about, because I understand there are 6 amendments?
7.
7.
And I'll move very quickly.
Very small, and
Yeah, very small, and,
you just review them
just-
all, and then we'll take them one at a time.
oh, you want me to go over them all first?
Okay. In general.
Okay, the First Amendment is simply adding the first due date for the inaugural report, the first report. We came up with this date, and we conferred with the public safety director, and this is a date that the public safety director is comfortable with issuing the first plan.
We don't have them all before us, just hold for a moment. Yeah.
Okay,
Let's
so,
get them all
so this,
over the time.
okay, so Amendment 1, okay.
I tell you what, we'll just, I thought you might just very quickly hit on what
I
each one is. If you could,
You want me to keep going, or wait till they're?
they need them in front of them. Okay.
We got 1 and 3 in front of us.
There's no 2 in your packet?
Oh, was that a packet?
They're all, I gave you a packet that has 1 through 6, and then the rest I was passing out individually. Tom had told me we were gonna go through them one at a time. We wanted to wait so
I don't,
I got 1 and 3.
let me see now. This is 2. I don't know what happened to the packet. 2?
You got the whole packet.
Yeah, I don't. He gave me something, but took it.
You have 2, right, Alderwoman?
Okay, we got 1 and 3.
You have 1, what do you have?
We'll do it
That's
just,
what we got
we'll
1
just
and
start with
3.
1 and take it on down.
Okay,
Let's,
okay, Amendment number 1,
I don't think they have it
1 and
down.
3.
Do you have the amendment?
does everyone have Amendment number 1?
Amendment number 1? Yes. Okay. I had a packet, but it's,
I didn't, I just got 1 and 3, and I didn't steal your packet.
You got
I'll just give me
your packet is right here.
That's it? Okay.
Where's the one I gave you? I just handed it to you.
I might have handed it to somebody.
All right, I'll
Not
get
a
the rest
problem.
of them out.
Okay, now you can go wrong with amendment number 1.
Amendment number 1 amends the bill. Amendment number 1 puts a date for the first public safety plan to be completed and submitted to the board. The date, we conferred with the public safety director, and the date that he was comfortable with the first report, because he wants to, make it a comprehensive report, was October 31st of 2019. So that's adding the words October 31st, 2019, on page 2, line 20, after the words completed by.
So we can entertain a motion for amendment number 1.
I'll make a motion, we adopt amendment number 1 to Board Bill 222.
Been moved and seconded that we adopt amendment number 1 to Board Bill 222. Any discussion on the motion? If not, Mr. Clerk, would you call the roll?
Alderman Boyd? Alderman Vaccaro?
Aye.
Alderman Cone? Aye. Alderman Arnowitz?
Aye.
Alderwoman Hubbard? Aye. Alderman Kotar? Aye. Alderwoman Spencer? Alderman Muhammad?
Aye.
Alderwoman Boyd? Aye. Chairman Kennedy?
Aye.
President Reed?
President Reed? Aye. This is amendment.
Amendment number 1.
Okay, by your vote, you have to announce it.
You have 9 aye votes.
By your vote, you sustain the motion from, to adopt amendment number 1. Amendment number 2.
Amendment number 2 deals with the appendix of the report as described on page 1, which asks for compiled tables of historical data. After conferring with the public safety director, he was more comfortable, and we agreed to reduce the amount of historical data from the prior 10 years to the prior 5 years. And so on page 1, line 16, it's striking out the word 10 and replacing it with the word 5.
Okay.
I'll make a motion, we pass amendment number 2 out on Board Bill 222.
Been moved that we adopt amendment number 2. Then
Previous rule.
it's been moved and seconded. There's been a request for previous, let the clerk catch up. Got it, okay. There's been a request for previous roll. Is there any opposition to previous roll? Seeing no opposition, you just passed, just adopted amendment number 2. Amendment 3.
Amendment number 3, and this also kind of is pertaining to the collection of data. So page 1, line 17, you know, where it states that the report will include historical data to prior now 5 years to the extent that it is reasonably obtainable. After the words obtainable, we list some sources of that information, and so adding after the word obtainable the words from the St. Louis Development Corporation's City Economic Growth Strategy Report and other St. Louis City agencies, districts, and departments. A majority of the information that will be included in this report, historical data, will also be a part of the SLDC's Economic Growth Strategy Report. So a majority of the information should be available to the Public Safety Director directly from SLDC as part of a previous board bill that hasn't finally passed yet, but is making its way through the board.
We can entertain a motion for amendment number 3.
I'll make a motion that we adopt amendment number 3 to Board Bill 222. Second.
Been moved and seconded. Been moved and seconded that we adopt amendment number 3 to Board Bill 222. There's been a request for previous roll. Any opposition to previous roll? Seeing none, by your vote, we've adopted amendment number 3.
Number 4 through 7 is not in front of us.
This is it.
We stopped at 3.
That's 4.
There's 4. Terry, if they don't want to leave it.
I'm fine. Just pass it on down. We're fine. Amendment number 4.
Amendment number 4 is just a grammar correction. It's adding some words on two sentences that kind of run together, but it's adding some words to, you know, just to correct that grammar. On line 8 is where the correction occurs, but if you read from line 7 on page 2, line 7 on page 2, it says the plan will be a tool that will provide data to the City of St. Louis and the Board of Aldermen, and we're inserting 2 words along with better information on the strengths and weaknesses of the city's public safety entities.
Okay.
And I will make a motion to adopt amendment number 4 to Bill 222 and previous rule.
Been moved and seconded that we adopt amendment number 4 to Board Bill 222. There's been a request, there's been moved and seconded. There's been a request for previous roll. Seeing no opposition, by your vote, we've adopted amendment number 4. Amendment number 5.
Amendment number 5, staying on page 2, line 8. This was at the request of the Public Safety Director, and we agreed with the change. After the word entities, on page 8, adding the sentence, or line 8, I'm sorry, page 2, line 8, adding the sentence, adding the sentence, the plan will be an information source during budget discussions, and the Board of Aldermen shall consider funding of programs, including in the report.
I'll make a motion that we adopt amendment number 5 to Board Bill 222, previous rule.
Been moved and seconded that we adopt amendment number 5 to Board Bill 222. There's been a request for previous roll. Any opposition to previous roll? Seeing no opposition, by your vote, we have adopted amendment number 5 to Board Bill 222. Amendment 6.
Amendment number 6, again, was after conferring with the Public Safety Director. There was a request for a little direction on some of the statistics and crime rates that would be looked for in the plan. This is not all inclusive, but if you look on page 2, line 13, where the sentence is finished, the public safety plan shall be a critical strategic analysis of the crime rates in the city. We're adding to the end of that sentence, comma, including, comma, but not limited to, comma, the categories of homicide, aggravated assault, rape, robbery, vehicle theft, burglary, reckless driving, human trafficking related offenses, and crimes committed by juveniles. And that's just to add some direction, but not putting any limits on the information of crime rates that we'll receive in the report.
I might have a question.
There are questions. Alderman Vaccaro?
Just the only question is, can we get information on juveniles, or is that blocked out to us?
Not specific ones, but
So it's okay?
Arrest
Then I'm fine.
Okay.
So I'll make the
We can
motion.
entertain a motion.
Yeah, that we adopt amendment number 6 to Board Bill 222 and
Been-
previous.
Been moved and seconded that we adopt amendment number 6 to Board Bill 222. There's been a request for previous roll. Is there any opposition? Seeing no opposition, by your vote, we have adopted amendment number 6. There's amendment 7.
Amendment number 7 is just a
We don't have
correction
that
on
in
a,
front of us
oh,
yet.
sorry.
Do you have a copy of it? Amendment 7?
Oh, he may not have amendments. Put it up there.
No, we could rewrote this. Thank you, Mary.
So Amendment 7 is just a correction on Section 5. It cites or lists a section from a previous board bill. Section 5, this is page 3, line 1, with Section 5, that the heading title of that section is from a different board bill. So it replaces the word City Economic Growth Strategy Report with Public Safety Plan.
page 3.
Page 3, line 1, the actual, in bold, the section 5 title is incorrect. It doesn't reflect this board bill.
Okay.
Just wanted to make that correct. Yes. Yeah, so we need to replace the word city economic growth strategy report with public safety plan.
Okay.
Then I'll make the motion that we adopt amendment number 7 of Board Bill 222.
Been moved and seconded that we adopt amendment number 7 to Board Bill 222. There's been a request for previous roll. Is there any opposition to previous roll? Seeing no opposition, by your vote, we've adopted amendment number 7.
There's one more amendment that was at the recommendation of the Alderwoman from the 27th regarding the crime rate data and the reporting of it. And what it does is add language that the public safety director will provide a report to the Public Safety Committee on a quarterly basis just on crime rates that are included in the annual public safety plan. Have to give credit where credit is due.
I don't know, it's getting a little shaky. Whose amendment is it?
Weren't you talking about this? Okay. We can entertain a motion.
I'll make a motion, we adopt amendment number 8 to Board Bill 222.
Second, previous roll.
Been moved and seconded that we adopt amendment number 8 to Board Bill 222.
Second.
There's been a request for previous roll. Is there any opposition to previous roll? Seeing no opposition, by your vote, we've adopted amendment number 8. That takes us back to the board bill as amended.
I just want to thank all the members of the committee who, I know it's been a long day for you all, for your indulgence. You know, Board Bill 222 is a very important board bill. Back when the city passed the balanced budget amendment, right, and also required the budget to be out of the Board of Aldermen at a certain period of time and finished and adopted, we did not know at that time that the markets were going to crash like they did just a few years ago. And some cities across America who did not have requirements for a balanced budget and requirements that the budget be out at a certain specific time, ended up having to file bankruptcy. St. Louis was not in that condition. Now, we suffered from issues of pension systems and things of that nature that all sustained losses during that time. But we remained solvent as a city because we were positioned for it. If we want to see the crime rate drop dramatically across our city, we're going to have a plan, and we're going to have a agreed upon direction and make sure that we actually apply funds to that plan so that we can address the issues across communities all across the city. This begins to give us that tool to do it. And I really appreciate the time that you've taken today, and I would greatly appreciate your wholehearted support for this bill moving forward, and would love to have as many co-sponsors as possible. Somebody has to handle it on the floor, because as the president of the board, I don't handle bills on the floor. But thank you so much for the time that you've given me today.
You can add me as a co-sponsor.
Okay, thanks.
We can,
Please add me as a co-sponsor as well, Mr. President.
Thank you.
are there any questions for the sponsor? If not, we can entertain a motion.
I think Shane has.
Oh, you had something? Alderman?
Can I just ask one question of the sponsor, please? Mr. President, thank you for being here this morning, or this afternoon now. So you had mentioned earlier, and I applaud your efforts to actually, have a regular public safety plan for the city of St. Louis that's, devised and worked in partnership with the public and this board in particular on the development of it. The peer plan was brought up during, I believe, your opening comments, and I'm just curious, as someone who represents one of the 15 neighborhoods that's, adopted in that peer plan, I've had my own level of frustration with the, implementation of it, but it is at least a fairly comprehensive plan if it were to actually be implemented in its entirety. Would you, in your estimation, would you view portions of that plan being pulled into this plan, or how do you envision that working?
Yes, the public safety director could take components of that plan, components of other plans from across the country, and put together a plan that would begin to address the issues in neighborhoods across the city. Now, here's an important piece. So let's assume for a second that they hit the mark somewhat, but we only drive our crime rate down 2%, right? Because of the data gathering component that's part of the ordinance that we're moving forward with, we will be able to adjust that plan in the out years. And then also because of the transparency that will now be required, we will be assured that the plan is actually being implemented. The challenge with the peer plan is that I don't know, nobody has been able to tell me solidly that it's actually been implemented past the document itself. Matter of fact, some of the folks within the police department and the higher levels of law enforcement that should be very aware of the plan and that should be working off of the plan each and every day, it is not something that's part of their working day. So this begins to change the culture of the system and begins to get the system working in a unified fashion so that we can begin to address issues all across the city. So I would think that if there are good parts within the plan, they should adopt them. If the whole plan is good, adopt it and make that the first plan we start out with. And then we will have our marching orders. We know what we would have to do. There are components within the plan that we need to assure are funded through the budgeting process. So
I guess that's been my concern with the peer plan, is that our budget realities don't reflect the kind of plan realities or plan ideals within the peer plan. And I've had the good fortune of also sitting on the planning commission over the last several years, or off and on during my tenure down here at the board. And the peer plan is actually adopted by the Planning Commission, and we adopted it down here at the Board of Aldermen as well when it first came out. And it doesn't seem, to your point, as though very much of it has actually been implemented. And I think the chair of this committee, at least once in my knowledge, possibly twice, since the adoption of the peer plan, has requested representatives from the administration, both the current and former, to come and provide updates with regard to the peer plan, but it's been scant in terms of the information that's been provided. And the last update that I remember seeing with regard to the peer plan was that they were reevaluating the peer plan without, and frankly, that's the last I've heard of it.
Yeah, and therein lies the problem. That's why cities are moving to a model where it's very highly regulated, so that there are set dates and times where things have to happen, right? And the ordinance will call out for that annual thing to happen, right now we're passing this plan, but if we find that we cannot get compliance in the future, we can look at how you begin to tighten up and find ways to tighten it up. But certainly with absent of it, we all have lived through a world where we're absent of it, and we can no longer afford to live in that world. I think that this is a great first step. I think it begins to move us in a much different direction. And if we have people that are willing to address those things in a real comprehensive manner on the other end, I think we're going to be all in much better shape. If not, then we at least have a tool to begin to hold them accountable. Otherwise, it's just otherwise a plan is just created to make us happy, and then they make us happy once and never report back to us, right? But when we begin to align budget priorities, right, with the realities of the numbers that are coming back from our neighborhoods and addressing these things directly, that's when we will see the change.
Were there any other questions, If not, we can entertain a motion for Board Bill 222.
Then I'll make a motion, we pass Board Bill up 222 as amended with the do pass recommendation.
Been moved and seconded that we adopt with a due pass recommendation Board Bill 222 as amended. There's been a request for previous roll? Been a request for previous roll. Is there any opposition to previous roll? Seeing no opposition, by your vote, we just adopted Board Bill 222 as amended for the due pass recommendation.
Thank you, everyone.
Thank you, Mr. President.
Thank you.
That completes our agenda for today. The meeting is adjourned.